Afternoon in Europe and good morning in the States. Warm welcome to a regular GMF briefing on Central and Eastern Europe. Our today online event is devoted to the European Commission's recent Rule of Law report that was published last Wednesday, and first time in the EU's history provides a comprehensive picture about the rule of law situation in all member states. No doubt, we are experiencing turbulent times when it comes to the safeguarding of rule of law in the European Union. Establishing a link between the quality of the rule of law and the disbursement of EU funds, the so-called rule of law conditionality that may put financial pressure on autocratizing member states, is one of the biggest challenges ahead of the EU's next 7 years budget and its coronavirus recovery fund. The two member states with the most alarming democracy and rule of law track record, Hungary and Poland, both signalized that they are ready to withhold their consent from the whole financial package if EU institutions and member states do not disband the idea of rule of law conditionality. A potential compromise with Warsaw and Budapest is neither in arm's length, nor would it necessarily benefit the rule of law situation in that member states. The Commission's rule of law report, the subject of our today's discussion, was released in this political environment. It was much awaited since the Commission announced the project last summer, and many hopes were attached to it, that it could be a sort of game changer in the struggle against the EU's democratic and rule of law device. However, its actual results appear to be somehow mixed. But how do EU member states compare when it comes to the rule of law? How did the Commission assess the quality of the rule of law, free media, and anti-corruption frameworks in the EU member states with the most striking rule of law deficiencies? How solid and consequential is the Commission's assessment? And how may its findings influence ongoing Article 7 procedures and the distribution of EU funds? We will discuss these and other questions with our 5 distinguished speakers today. Petra Bárd, visiting professor at the Central European University. Joachim Herrmann, member of the cabinet of Didier Reynders, Commissioner for Justice in the European Commission. Laurent Pech, professor of European law at the Middlesex University, London. Radosveta Vassileva, legal expert and former lecturer at the University College London. And Wójcik, legal expert, co-founder and editor of Rule of Law in Poland, a highly influential platform covering Poland's constitutional backsliding. My name is Hegedüs, and I serve as fellow for Central Europe at the German Marshall Fund of the United States. Concerning the housekeeping rules, the initial contributions of our panelists will be limited to the first half of the webinar, with the individual statements not exceeding 10 minutes. In the second half, we will have approximately 45 minutes for the Q&A and discussion. Thus, I would like to encourage you, ladies and gentlemen, to send me your questions via the chat function of Zoom, that I can bunch the questions together and can forward them to our panelists. I also would like to remind you that the event is recorded and will be available online at the YouTube channel of the German Marshall Fund. And because we would like to involve you actively in the whole discussion, ladies and gentlemen, before we jump into the contribution of our panelists, we would like to start with a polling question. You can simply answer the question with a yes or no. Is the European Union doing enough to maintain the rule of law and democracy in its member states? You have 30 seconds to answer the question. Does the European Union, its institutions and member states do enough to maintain democracy and rule of law, all the founding values enshrined in the treaties in the European Union?
Daniel, it's not fair, I cannot vote.
That's true, but I think we will be able to know your opinion some minutes later. So thank you very much, ladies and gentlemen. The polling is over, and we need some seconds until we can see the results. And I think the results are pretty straightforward. 88% of our attendees have the opinion that the European Union, its institutions and member states are not doing enough to maintaining rule of law and democracy in EU member states. Of course, these results are definitely not representative, but I think they provide us interesting food for thought in front of our conversation. And following our poll and coming back to the rule of law report, Mr. Herrmann, could you give us an overview of this exercise called the rule of law review cycle? What were the Commission's main goals with the report? What were its main expectations? What methodology was applied? And what are the main results? Mr. Herrmann, the floor is yours.
Thank you very much, Mr. Hegedüs. It's a pleasure to be with you today here and with participants. I'm very proud to present to you the Commission's Rule of Law report. Its publication of the end of November put into place a piece that is a centerpiece of the new European Rule of Law mechanism. Let me maybe start by recalling that we already have in place a toolbox of the European Union to address rule of law problems, and that there we have a number of instruments that are often reactive in character and that address specific situations in member states. For instance, infringement procedures or the Article 7 procedure. Now, the rule of law mechanism is the first time that we are having a systematic reflection on the situation of the rule of law in all member states and in a preventive manner. It's an important step forward for us to reinforce the interinstitutional cooperation on this matter. So I would launch a discussion by saying that this report will allow us to enter a new stage in the protection and promotion of the rule of law in the European Union. And to explain this a bit more, I would like to start off by saying, what is the rule of law mechanism about? It is a new instrument that is foreseen in the political guidelines of President von der Leyen, and has the rule of law report of the Commission at its center. And the objective is to deepen the dialogue and to increase the joint awareness of the rule of law throughout the European Union. So what are the characteristics of the rule of law mechanism? First of all, the mechanism is a yearly process during which we aim to prevent problems from emerging or deepening. But I should also say that we don't only want to look at the challenging developments, but also at the positive one, at positive experiences and good practices that can inspire other member states to follow them. And I would also like to start off as a characteristic that the report makes a clear difference between punctual concerns that exist and more systematic issues. I think it's also important to bear in mind when discussing the mechanism how the rule of law report was established. To set up the mechanism, Justice Commissioner Reynders wrote in January to all 27 ministers of EU affairs in order to establish a network of national rule of law contact points in every member state. And this was instrumental not only as a constant channel of communication with member states, but also to discuss the methodology that is underlying our report. And I'm happy to say that on this basis, all 27 member states participated and provided written input based on a methodology that was discussed with them beforehand. We also carried out a targeted stakeholder consultation where over 200 stakeholders provided written input. And this included, for instance, EU agencies, national European civil society organizations, and professional associations. On top of this, on this base of all this written input that we received, the Commission had country teams that conducted more than 300 virtual country visits. And during these country visits, we discussed rule of law developments with member states' national authorities, for instance, with judicial and independent authorities, and again, with relevant stakeholders, such as, for instance, journalist associations. And last but not least, every member state had the opportunity to check its draft country chapters for factual accuracy. I would like to say again that I think it's a very good result already that all member states participated in this process, and that this is a process where all member states were treated strictly equally. We applied the same methodology to all member states and constantly ensured consistency. We have also kept at political level the Council informed about the progress, and of course also the European Parliament. And we made sure that this process was robust, transparent, and as inclusive as possible. But in the end, let me also be clear that this report represents the Commission's own assessment. Now it's maybe good to point out some key findings in this report. To start with, we looked at 4 key areas. The first one being the independence, quality, and efficiency of justice systems. The second one, the anti-corruption framework. The third, media pluralism and media freedom. And finally, other institutional checks and balances. Now, speaking about the independence, quality, and efficiency of justice systems. I appreciate that in a number of member states, efforts are underway to strengthen judicial independence and reduce the influence of the executive or legislative power over the judiciary. For instance, the setting up and strengthening of independent national councils for the judiciary is a good example of how some member states have been indeed making concrete efforts for more judicial independence. But it's also true that judicial independence remains an issue of concern in certain member states. For example, we identified issues related to the capacity of councils of the judiciary to exercise their functions. We have also more structural concerns over an increasing influence of the executive and legislative branch over the functioning of justice systems, including constitutional courts and supreme courts. In terms of quality, the current pandemic has highlighted the importance of digitalizing justice systems. Many initiatives are ongoing in member states to deliver real improvements for the users of justice systems. Some justice systems are already equipped with technology to operate remotely, to carry on communication with lawyers and other court users, and these are, of course, then good practices to share. Speaking secondly about anti-corruption, that's another area where divergences exist. Several member states have adopted comprehensive new anti-corruption strategies or revised existing one, and this is a positive trend. What will, however, be key then is that these strategies are effectively implemented and monitored to ensure that progress is made. In some member states, measures have been introduced to strengthen institutional capacity to fight corruption and to reduce obstacles to effective prosecution. But it is also true that our monitoring shows concern in several member states about the effectiveness of the investigation, prosecution, and adjudication of corruption cases. This includes concerns that high-level corruption cases are not systematically pursued. Now, speaking thirdly about media pluralism and media freedom. First things first, the independence and competence of media authorities is enshrined in law in every single member state. This being said, there are red flags with regard to the political influence on the media in some member states and the lack of transparency when it comes to who owns media in other member states. We also flagged, in certain cases, a lack of pluralism in the media landscape and a risk to journalists and other media actors when doing their work. The fourth and final area of our report are institutional issues linked to checks and balances. On the positive side, there's a healthy debate on strengthening constitutional safeguards in some member states. Indeed, in a number of member states, reform processes are underway. In particular, they concern the opening up of new channels for citizens to challenge the exercise of executive and legislative power. The advice of international expert bodies, such as the Venice Commission, can support these processes. And the COVID-19 pandemic actually also provided some good examples of functioning checks and balances. Parliamentary scrutiny helped frame emergency responses, and measures taken were often reviewed by courts. However, we also identified a number of rule of law related concerns in this area. In a few member states, we see repeated recourse to fast-track legislation in Parliament or emergency ordinances from government. Moreover, in some member states, civil society lacks an enabling framework, faces diminishing space to operate, legislation that limits access to foreign funding or smear campaigns, to name but a few examples. But speaking about the European rule of law mechanism, I think it's also important to stress where we intend to go from here. The comprehensive rule of law mechanism is, after all, more than the report itself. What we want to achieve through this report is a true dialogue at EU and national level with the European Parliament, with the Council of Ministers, with national parliaments, as well as European and national stakeholders. And this dialogue is also part of the mechanism. We want to promote the rule of law across Europe. As you may know, the German presidency intends to have a rule of law dialogue in the Council based on our report. There will be two discussions in the General Affairs Council, a horizontal discussion, covering general rule of law developments in October, and a country-specific discussion addressing key developments in specific member states in November. And the Commission also invited the European Parliament to follow up on the report. We also need to advance the debate at national level, and we would like to warmly invite national parliaments, stakeholders, civil society, and academics to discuss the conclusions of the report. To conclude, let me stress that the mechanism does not stop here today. Everyone, European institutions, Parliament, academics, experts, civil society organizations, journalists, and all citizens of the EU are invited to take part in this dialogue. And in that sense, I hope that this is a real step forward to enrich the toolbox that the EU has to address rule of law problems. Thank you very much for your attention.
Thank you very much, Mr. Herrmann. I am sure that there will be plenty of follow-up questions, and also would like to encourage you, ladies and gentlemen, to submit your questions via the chat function of Zoom. And going forward, Professor Pech, how does the review cycle fit into the broader picture of what could be provocatively called the EU's rule of law crisis? How would you draw the balance of the reports? How far were the goals of the exercise and the expectations attached to it fulfilled? And in spite of all of the critics, what do you think? What is also the greatest achievement of the review cycle? Professor Pech, you have the floor.
Thank you very much. I'm just going to share, I'm going to try to share my screen. Let's see, where is my, I'm going to try to find my PowerPoint, if that's okay. So bear with me for a minute. That's it. I'm going to answer you many questions. I mean, I'm going to try my best because I've got only 10 minutes and your questions are quite difficult to answer very briefly. But let me begin by essentially going a bit back in time and just to look at the evolution of the EU rule of law toolbox since the start of the EU. Very briefly, obviously, I've got only 10 minutes. The main point I want to make at this stage is essentially that the new rule of law review cycle put forward by the Commission is just the latest addition to the EU rule of law toolbox. As you can see, in fact, from the slide, possibly, that we have had many new tools being adopted in the past 10 years. In fact, you could speak of an exponential creation of tools ever since President Barroso, of the then President of the European Commission, in 2012, 2013, referred to a new type of threats to the rule of law and democracies in the EU. Not everyone remembers that, in fact, the rule of law crisis did not begin last year. In fact, it was first spotted by Barroso and Viviane Reding in 2012, 2013. Then Hungary, Romania, and France were mentioned as three problematical cases. On the back of this diagnosis, the Commission came up with the pre-Article 7 framework, known as the rule of law framework. So now the new rule of law review cycle is just the latest addition. I'm not going to go through each element of the toolbox, but I wanted to draw your attention to the fact that we have had many new tools. Then the question is, we have two possible interpretations regarding the multiplication or the deepening of the toolbox. The first possible interpretation is that essentially the positive interpretation is that the EU institutions have woken up to the new type of threats to the rule of law and are trying to do something meaningful about it by multiplying instruments and tools. The more negative interpretation, which would be mine, is that instead of meaningfully act in relation to rule of law threats, Instead of addressing rule of law threats through mostly infringement actions, we have been multiplying tools, and we kind of facing instrument cycle creation. Every 2 years, we come up with a new tool, having concluded that the previous tool is not working. Now, I'm not sure whether this is going to be the situation in 2022, after 2 editions of the new rule of law cycle. But I'm just saying it's an open question whether the multiplication of tools is actually an answer to the problem or just a distraction. Now, regarding this new rule of law cycle, I have essentially decided to give you a critical overview of the main shortcomings. You asked me whether there are anything positive about the new rule of law cycle. I would say potentially yes, if you take a long-term view. But if you take a short-term view, I'm afraid I only see shortcomings rather than positive impact, at least the short term. So let me explain what I view as the main shortcomings and weaknesses. My time is limited, so essentially you can just refer to the slide, but my main concern, and this is the first on the list, is that even though Commissioner Jourova and Commissioner Reynders have positively, in fact, referred to the different elements being connected, and in fact, Commissioner Jourova spoke of an undrinkable cocktail when you connect the dots. My problem with the transversal report is that it does not connect the dots, actually. So you have 4 main topics, which are clearly relevant. There are critical issues. I don't disagree with the choice of topics. They are crucial topics. But the transversal report fails to paint a systemic picture, even though some of the country reports do give some implicitly transversal review if you really look between the lines. But essentially, this is my first concern. If you read the transversal report and you are not an expert, you're not going to be able to really realize that essentially the EU has been confronted with at least two cases of dramatic autocratization in the past 10 years. So there is a failure to see the wood for the trees in a lot of instances. There is also a denial of reality, I'm afraid. Just for instance, even though the Polish report, just very briefly, I know Anna is going to go back to it. The Polish report is very good. Technically, there's very little missing. It's legally accurate from my point of view. It's very good. However, the language essentially, again, is just simply disconnected from reality. When you see the Commission using the word reforms to describe what has already been found violations of the rule of law by the Court of Justice, there is something wrong. I could multiply examples from other reports. My time is limited. There is also a denial of autocratic reality. You read the report, you don't understand that in fact, some of the member states, in fact, at least one, and that's my next also shortcoming, you cannot really clearly see that some of the weaknesses or violations of the rule of law are actually of a deliberate nature. You don't see that when reading the transversal report. It's very important to understand that the main threat to the rule of law is what I have called rule of law backsliding, which is a deliberate process of dismantling checks and balances. Until you understand this, you're not going to be able to meaningfully come up with solutions. These are not by chance minor shortcomings of the rule of law. This is part of an overall blueprint to destroy the rule of law, to destroy the judicial independence component. Until we accept reality, we're never going to come up with meaningful solutions. There is also a category error to the extent that we are comparing oranges with mushrooms, as I put it a few days ago. Just to give you an example, I know it's sad, I know it's difficult to accept, but we have at least one non-democratic country in the EU. So you cannot apply the same methodology to a democracy and a non-democracy. It doesn't make sense, because then what does it mean? It means that you are comparing oranges with mushrooms to the extent that essentially you're comparing two different objects. You cannot really assess the shortcomings when it comes to the rule of law in a democratic system and in a non-democratic system. And I will refer participants or listeners to the VDEM report on democracy 2020. And then you can see that Hungary is actually the most severe case of autocratization in the world in the past 10 years. You don't see that in the transversal report and not even in the country report. Fifth, the reporting cycle has been presented as a preventive tool. I don't really understand why it is described as such, because for me, it's mostly an after the event reporting tool. I'm not saying that reporting after the events is not good, but I'm just saying I don't see how, to which extent can this set of reports have any meaningful preventive effect. I just don't see it. In fact, I wrote a paper last year saying that when it comes to dialogue with legal hooligans, as I call them, that is people engaged in deliberate destruction of judicial independence, after the event reporting serves no useful purpose. It might be interesting just to build a knowledge base, yes, but the preventive aspect of it, perhaps we can debate it later with other participants and fellow panelists. And then last but not least, I feel that the annual rule of law cycle has had a distractive effect, in fact, not a preventive effect, it's having a distracting effect to the extent that the Commission has limited resources and can only have limited priorities. Perhaps I'm wrong, but perhaps I'm right. But where I'm sitting, having studied rule of law shortcomings in the EU for quite some time, I'm afraid what I have seen is that the production of this report has really essentially possibly cannibalized the limited resources of the Commission. And perhaps the negative side of the coin is that we have seen very little action on the infringement front. As far as I can see, you can correct me if I'm wrong, but since the new Commission started, we have had only one new infringement action regarding the Polish muzzle law. Very much welcome. However, we still have yet to move to the reason opinion phase. So, and if you look beyond before the VDL Commission, we have had, since Barroso came up with his diagnosis, we have had no more than 5 infringement actions in 7 or 8 years to defend judicial independence in the EU. There's something deeply wrong on the enforcement side. Now, perhaps we can discuss another day the reasons for the lack of enforcement for infringement actions, but for me, this is possibly the negative short-term impact. I'm not sure whether the Commission has the resources to do both, to do the monitoring side and to do the enforcement side, but we can have a debate about this. Just to conclude, this is what a number of rule of law experts wrote last year before the Commission decided to go for the annual rule of law cycle. I'm afraid this is not simply to tell you, I told you so, but I'm telling you so, yes. In fact, I'm afraid what we suspected would happen has happened, to the extent that from my point of view, possibly it was the wrong priority for the Commission to have. Now, to be fair to the Commission, to a large extent, the Commission never wanted actually a rule of law review cycle. I've been working on the DRF Pact of the European Parliament a few years ago, you know, the new permanent cycle involving all EU institutions, which was pushed then by Sophie in 't Veld, MEP. In 2016, and then the reaction of the Commission is we didn't want it. To some extent, when we wrote this paper in 2019, I think the Commission is right, or was right rather, that at this stage possibly we should prioritize enforcement, but no, in fact, we came up with a new rule of law cycle, which is however suffering from a number of shortcomings. My time is limited, so my main point is possibly to discuss later. As the rule of law cycle, in fact, being used as an excuse not to enforce the law, or possibly to put it more positively, as the rule of law cycle used all of the resources of the Commission and therefore leaving the Commission with not enough time and resources to focus on enforcement. Thank you very much.
Thank you so much, Professor Pech, for this concise and critical overview. And ladies and gentlemen, I also would like to call your attention to our in-house fast evaluation GMF published last week. You can access it via the URL I am sharing with you soon. But now let's switch our perspective from the overall picture to the countries mostly affected by the demise of the rule of law. Ms. Wójcik, among all the EU member states, the Commission painted the darkest picture about the situation of the rule of law in Poland. What is your assessment about the Polish country report? Where was the report successful in establishing the facts, and where did it fail to capture the situation in Poland? And how was the perception of the report in the government circles and in the Polish civil society? You have the floor.
Thank you for the invitation, for the opportunity to comment on the Polish report. I would say that the report has been received in the background of the resolution and the report prepared in the European Parliament that was more blunt and reflected on developments that happen in Poland in a very straightforward way, and that must have influenced the reception of the report in Poland recently. Another factor is that we have had a government reshuffle. Actually, as we speak, the third Mateusz Morawiecki's government is being sworn in. So a lot of attention has been put to Polish national politics, not on to this report. But also, I think the report was a relief for, could have been a sort of relief for national authorities in Poland, for the government in Poland, because it does indeed present a very fact-based overview, at least in the section on the judicial independence. Speaking as a person from civil society organizations, I would say that it is a very good backgrounder, like a comprehensive introduction in the judicial independence section for someone who hasn't followed developments in Poland in the past 5 years. Also, it has a great bibliography, and it refers to documents and to the facts that have been established in many documents of the European Commission, in judgments of the Court of Justice of the European Union, but also it references, as far as applicable, to the European Court of Human Rights cases or other regional human rights instruments. Documents. So I think this is good. This is a good introduction, and I absolutely agree that this is well done. And I think to a huge extent, it is thanks to extensive network of civil society organizations in Poland that were willing to share their expertise and their work. And what is really remarkable is that both the Human Rights Commissioner Office and the Commissioner himself, Professor Bodnar, and dozens of civil society organizations for many years have been really painstakingly monitoring and writing about what is going on in different areas related to judicial independence. So now we can, I think that people who prepared this report had a helping hand from those experts as well. What I liked about the report was also a focus on human rights dimension, which is acknowledging the fact that in the past 2 years, there has been a shift in human rights protection standards in the areas of freedom of expression, and also those changes that had been introduced after 2015 were not reversed, especially in the areas of freedom of assembly and also freedom of expression. And what distinguishes the Polish report from the Hungarian one, for example, is that it at least refers to the fact that we are going through a process that has been going on for the past 5 years, not only in 2019, 2020. So I think this is a big advantage of the Polish report. What I found was missing, especially in the sections on anti-corruption framework and on media independence, media freedom, was that it was too based on the provisions of law, on structure, like a legal structure, but also institutional structure that is in place, without acknowledging the actual political culture and how those institutions are working, who is in charge of them. There was briefly the Central Anti-Corruption Bureau, which is being overseen by the Prime Minister or a Deputy Prime Minister, and from now on it will be leader of the Law and Justice Party, Jarosław Kaczyński. It is overseen by a politician, and that was presented as a factor that undermines independence. But if I was a person who has very limited knowledge about Poland, it would be very difficult to me to actually imagine the scale of state capture, the scale of corruption scandals, even information that in the past 2 years Poland was rocked every month by news that there might be some abuse of power, abuse of state funding. I didn't find any information about the alleged abuse of the Justice Fund that is administered by the Justice Ministry in the report, despite that it is quite well documented but by independent researchers and by journalists. So I think that such element of a lived experience is important. I know it's not an anthropological exercise, it's an ethnographic work, but also regarding the independence of the media. We have a section which focuses on relations between the National Broadcasting Council and the body that was set up to actually perform its functions. But from the report, we would never expect that the state broadcaster in Poland is actually a propaganda machine that supports a narrative, a governmental narrative that, well, is very far removed from being reliable and accurate. And I think that these factors are crucial to assess the state of democracy in Poland and also the rule of law. And we don't see how those, as Professor Pech said, that how those elements of the puzzle actually influence each other. So we don't see this cumulative effect in the Polish case. It was mentioned to some extent that, for instance, investigating corruption might be more difficult because of the lack of guarantees or dismantling of the guarantees of judicial independence, but it's not that evident. And it really, each of those sections is connected to another. And I think that is really important. Also, on the final note, I think that too little attention was paid to what happened during the first months of pandemic in Poland. It is only briefly mentioned. And we had a lot of constitutional issues, including elections that, didn't take place. And we have big issues regarding accountability of public officials for these elections right now in Poland. Also, I'm happy to hear from the report that actually it was straightforwardly put that the government participated in a campaign, in a smear campaign against LGBTI people in Poland, which is indeed the case. It could be expanded a little bit to allow people to understand better such phenomena. Also, there's almost nothing about the smear campaign against judges, and also against other minorities and groups, including professional groups such as doctors in Poland. And I think it's important to understand how living in such a country that is autocratizing really feels. So my time is running, so I will just briefly mention the reactions to the report. Because so much media and government attention was on who will become deputy prime minister or justice minister, I think that the reactions were not very harsh. Interestingly, the recommendation from the report that the Minister of Justice and Prosecutor General should not be the same person has not been implemented, because it's still the same person, Mr. Ziobro. And the government issued a joint declaration, Polish Foreign Affairs Ministry and Hungarian Foreign Affairs Ministry, that they find the report methodologically inaccurate, unreliable, and criticize precisely the reliance on sources which they consider as being foreign funded and political and ideological enemies or critics to the democratically elected governing majority. Also, the Deputy Justice Minister Sebastian Kaleta accused the European Commission of hypocrisy. The framing in the state media is that the Commission has been discussing how to punish Poland for lack of the so-called rule of law. So which is quite surprising, because the rule of law has been defined in the general report and as being, concept grounded in European law of the Council of Europe. But the Polish government still continues this narrative that we know so well since many years. And also, I appreciated the brevity of this report for someone who is just learning about what's happening in Poland, but it's only 26 pages. And recall the white paper produced by the Polish government in 2018. It was 96 pages of, not very good arguments, but of an analysis and attempts at deflect the criticism that was targeted at Poland back then. So I will be happy to explain recent developments and maybe some further developments in Poland that are expected in the second part of the seminar. Thank you.
Thank you so much, Ms. Wójcik. I am sure we will revert to the Polish country report in the Q&A part. But there is a broad academic consensus that Hungary is still the unchallenged champion of authoritarian developments in the EU, with an authoritarian state capture that goes far beyond the situation in Poland. Traditionally, this picture is not mirrored in the Commission's assessment. Professor Bárd, how can this discrepancy be explained? How far can you agree with the main findings of the Hungarian country report? And how did the Hungarian government and civil society react to the document? Over to you, Professor Bárd.
Thank you very much. After such an exquisite introduction of the jurisdiction I'm going to cover, this is certainly going to be a challenge. I think that the expectations were huge around this rule of law report. They were mixed, but they were huge. They were mixed because of the bumpy start of the Ursula von der Leyen Commission, both in terms of personal choices, because of baptizing portfolios, but also in terms of being the guardian of the treaties, hardly starting any infringement procedures, as Professor Pech already mentioned, and not showing much progress on Article 7.1 procedures. The Commission was often blamed for being a giant rule of law defender in terms of words, but a dwarf in terms of action. So did the Commission live up to the huge expectations or not? It has mainly been summarized by Mr. Herrmann exquisitely. But yes, on the plus side, it's great that it's a regular report, so it's not an ad hoc one. It's an equal basis. It's on an equal basis, treating all member states equally. It thematizes multiple very relevant issues. It tries to render a qualitative assessment, and indeed multiple stakeholders fed into the report. The selection of the issues that are tackled makes to some extent the member states comparable, but at least, even if this is not the objective and probably shouldn't be the objective of the exercise, it gives at least an overview of where Europe stands in terms of the rule of law. In relation to Hungary, it gives a devastating picture and mainly giving a selection of issues that prove complete state capture, with very little positives, and even when we look at the positives like the speed of the procedures or the digitalization of the judgments, they do not concern the merits, because even kangaroo courts can be super fast. In fact, they are much faster disregarding procedural rules than ordinary courts, and their judgments can be digitalized too. So I'm not saying that Hungarian courts are kangaroo courts. All I'm saying is that these two strong points, or the very few strong points, do not remedy the weaknesses of the quality of justice or any other matter that is tackled by the rule of law report. On the minus side, I could identify two main problems, and then there are sub-issues that I will list. One is substantive and the other is procedural. Substantively, although the report tries, it could not grasp the systemic nature of the problem. And second, procedurally, it did not offer any remedies. So we still don't know what is going to happen with the text. Let me say a few words about the first issue. First of all, the document doesn't mention crucial issues. It has already been mentioned by Anna Wójcik that unlike the Polish report, the Hungarian report only covers happenings of the past couple of years. And it, for example, doesn't talk about the capturing of the Hungarian Constitutional Court, the restructuring of the ombudsman system, or any other issues that happened in the distant past. So a reader who is unfamiliar with the long chronology of rule of law backsliding in Hungary would not grasp that we are facing a decade-long systemic attack against constitutionalism. When topics are mentioned, the Commission oftentimes fails to connect the dots. The new possibility, for example, granted to public authorities to challenge court decisions before the Hungarian Constitutional Court is not only violating legal certainty per se, but it is also problematic exactly because the Hungarian Constitutional Court is already a captured court. There are other instances where more contextualization wouldn't have harmed. For example, when judges are being attacked, they are blamed for intermingling with politics. So there is no way for them to protect themselves in the media because they are immediately set to override other branches of power or interfere with other branches of power. However, the hostile media directly attacks judges and judgments. So judges remain entirely defenseless. This is basically how media pluralism, or the lack of it, and the issue of judicial independence are intertwined. When it comes to condemning the court decisions on the compensation of Roma children who had been segregated, the report emphasizes that the government wanted to organize a national referendum or a public consultation, a national consultation on the issue, just like on the issue of compensation of prisoners, and this would have undermined public trust in the justice system. Now, this is a minor issue compared to the fact that first, Hungary has been condemned by the European Court of Human Rights in a pilot judgment because of the heinous prison conditions. Then, because it did not want to comply with the judgment and it did not want to change its penal policy, as it was recommended by the Strasbourg court. It instead, in order to preempt further Strasbourg judgments, created a fast-track system for compensation. Of course, it doesn't mean that the prison conditions are not heinous anymore. It only means that the prisoners, or some of them at least, are being compensated. And then this national compensation system was attacked in front of the public. Also, they managed to connect the compensation of Roma segregated children with that of prisoners, which was also another wonderful example of populism connecting Roma to criminality immediately. And what is more, and absolutely crucial from the point of view of separation of powers, with a law, they overwrote national court decisions. And this is simply not reflected in the report. With regard to corruption, one may have expected the Commission to list all of the Olaf reports and procedures indicating how much money was used against EU rules. It only gives a number of procedures. And against this background, it could have listed how many national procedures have been started in relation to the same amount of money. Instead, we see that the problem is that the asset declarations of senior civil servants and members of parliament are not systematically verified, which shows a great deal of naivete in a country of strawmen, where the wealth of the childhood friend of the prime minister grows at a greater speed than that of Mr. Mark Zuckerberg. So the standards employed in a democracy, whether they can be applied also in a country that is, according to international observers, is not considered to be a democracy, also mentioned by Professor Pech. But as I look at the chat questions, there was a similar question asked by István Hegedüs, president of the Hungarian Europe Society. Well, these standards might not function very well in autocracies, even if I understand that this is a very tricky question, how to apply different standards, and it might not even be doable. All I'm saying is that the praise, for example, for the adequate funding of the media authority, whose independence, however, is not existent, according to the report itself, quite to the contrary, it proactively supports government outlets and harasses opposition ones. So is it really a virtue? Is it a virtue to finance the enablers of your own autocracy? All in all, there is also very soft language at several instances, like, for example, I quote, "The independence and effectiveness of the Media Council is at risk," unquote, whereas international observers already documented a complete media capture. So we see this soft language, the scattered nature of isolated cases without connecting the dots, without context, combined with the fact that the weaknesses and good practices are collected everywhere in each and every single member state, gives rise to increased whataboutery. For example, the Hungarian Justice Minister dedicated a website to whataboutism, mentioning issues from the Finnish Sami minority to the Netherlands getting rid of referenda. I don't have much time to deal with the second issue, but all I wish to say is that the report corresponds to the earlier stance of the von der Leyen Commission, namely, and I quote, not the first sanction at the beginning. Indeed, this is supposed to be a preventative tool. I don't know whether it really makes sense to talk about prevention with regard to Hungary. To borrow from Daniel Kelemen, it's as if you bought a fire alarm at the time your house was already burning. And finally, dialogue. The document itself admits that it wishes to engage in a dialogue, and it was very emblematic that Commissioner Jourova emphasized during the press talks when the country reports were issued, that her door is always open to even more dialogue, even with Hungary and the Hungarian government, which was interesting because less than 24 hours before, Hungary just suspended all diplomatic relations with Commissioner Jourova. So I think this is just another trick on the side of autocratic government not to go into the merits. It's just another thing, just like saying that the rule of law is a political concept, or it's a matter of honor, or that somehow it's a freedom fight for national sovereignty not to respect constitutional rules, or just to cite word by word my prime minister, it's quote, simply blah, 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 unquote, that there are double standards. There's a Central European understanding, alternative understanding of the rule of law, and so on and so forth. So we have come a long way in dismantling constitutionalism, and I'm afraid that this very friendly sunshine approach might not help. All in all, we have yet another set of problem mapping, for better or for worse. The real question is what will happen to it? Because for now, we do not see a prompt and dissuasive, effective response. And this is regrettable both for Hungary, a country where there are no more effective checks and balances, and the EU should act as an external check to some extent at least, but it is also regrettable for the European Union, for which a firm and clear stepping up against rule of law backsliding in a national setting would also be existential. Thank you very much.
Thank you so much, Professor Bárd. Bulgaria is traditionally in a special situation, as following its EU accession in 2007, a special mechanism of post-accession conditionality called Cooperation and Verification Mechanism, CVM, was attached to the country that empowered the Commission to closely monitor rule of law and corruption-related developments, and also to exert leverage over the Bulgarian government. Ms. Vassileva, how is it possible that in spite of this attention and leverage, the rule of law situation in Bulgaria is one of the most alarming in the European Union? How would you evaluate the Commission's recent Bulgarian country report? Over to you, Ms. Vassileva.
Thank you very much for having me. I have to admit that I read the report with great interest, exactly for the reason you mentioned, that Bulgaria has been subjected to the CVM for 13 years. In addition, I've been following rule of law decay in Bulgaria for quite some time, and many of my conclusions are corroborated by the 3-month-long epic protests demanding the resignation of Boyko Borisov's government and the resignation of the General Prosecutor of Bulgaria, Mr. Ivan Keshev. Now, unfortunately, my conclusions about this assessment by the Commission are rather negative. I think, in my view, this is an example of Pontius Pilate washing his hands. I have 3 main reasons to put forward to this end. What the report says is true. It's factually correct. It's just that it presents 40% of the picture. 60% of the picture is missing, in my view. And I think that evidence to this regard is provided by the rather spicy, quite straightforward resolution that the European Parliament has in store for Bulgaria. And this afternoon, we have a plenary debate on the lack of rule of law and severe breaches of fundamental rights in the country. In addition, the 40% of the picture, which is in this assessment, is painted in very diplomatic colors. And in this way, it could be read both in a positive and in a negative light, depending on who you ask. If you ask the government, they're very happy. Mr. Borisov said that he was very satisfied with this report because it recognized a lot of progress he has achieved. However, the report misses key challenges that Bulgaria faces, and also all corruption scandals in which Mr. Borisov is allegedly involved have been missed, while less important scandals have been mentioned. Meanwhile, some critics are also happy with this report because for the first time, and here the Commission should be congratulated, it articulates some challenges that Bulgaria faces in a more direct, straightforward manner. So it doesn't really sugarcoat some problems anymore. What I also noted is that, and this is unfortunate, I have a feeling you're not hearing me, or
we can hear you perfectly.
Okay, sorry, because I saw this look on your face. So some problems that have been identified by the Commission, unfortunately, could be directly linked to compromises the Commission has made under the course of the cooperation and verification mechanism, or the CVM that you mentioned. And here I would like to provide several examples where the full picture is missing. And now let's start with the with the elephant in the Bulgarian room, and this is corruption. And this is a theme that runs through this report, both in the section on the justice system and on the anti-corruption framework. Now, what's positive is that the Commission uses metrics by Transparency International that Bulgaria is, at least according to Transparency International, the most corrupt member state in the European Union. The Commission also alleges that the protests have highlighted the lack of results in fighting corruption. And here we also have a copy-paste from the CVM. It declares that Bulgaria hasn't built a long track record of final convictions on corruption. And here, the problem is that the purpose of the protest is somewhat misrepresented. These are not protests against corruption at large. These are protests against the concrete corruption by Mr. Borisov, his government, his party, his behind-the-curtain partners, and also the corruption of the prosecutor's office. And in the current framework, none of these issues and serious allegations can be investigated. So on the end of the prosecutor's office, the Commission in this report has rightfully noted that it has a centralized structure, and in addition, there's no mechanism to hold a serving prosecutor general accountable for crimes he committed in office or elsewhere, in fact. And this is a problem which has been long known to the Commission since Kolevi against Bulgaria, which was rendered 10 years or 11 even years ago. And so for nearly a decade, the Council of Europe has been playing a cat and mouse game with Bulgaria, trying to persuade Bulgaria to comply with this decision. Meanwhile, in the CVM, the Commission was very diplomatic and nonchalant. At some point, it even had the exotic idea that the prosecutor's office had to reform itself. And in the last CVM report, it noted that this was a complex issue for Bulgaria and maybe it would take some time to resolve. But it has been 10 years, and how much longer can we wait? Now, on the end of the alleged corruption of the government, experts concur, or many experts concur, that the prosecutor's office is a political puppet, and there is direct and indirect evidence to this end. And there are many issues of concern regarding the way the general prosecutor is elected, because he's elected by the Supreme Judicial Council, which is heavily politicized. And 5 years ago, Bulgaria had a reform of this Supreme Judicial Council, which was, I would deem, it was cosmetic, and it didn't resolve most challenges this institution faces. And so it has remained as a political institution. And yet this reform 5 years ago was recognized as progress by the European Commission in the CVM. So there are many issues here that have their roots in the CVM, or omissions and compromises in the CVM. On the note of final convictions on which the Commission insists, part of the picture is missing too, because these would matter only after an objective investigation and only after a fair trial. Now, Bulgaria has a long, troublesome track record of losing cases before the ECHR because of severe violations by the prosecutor's office, and this has been omitted in the report, yet it has been mentioned in the draft resolution that the European Parliament has planned for Bulgaria. And in addition, of course, for that to take place, one needs an independent judiciary, and Bulgarian judges are consistently subjected under attacks. And here in this report, we only have one sentence about this in passing. And I actually think it's a positive thing because it's the first time there is a straightforward recognition of these assaults. However, I want to point out that in 2018, the European Commission closed the Judicial Independence benchmark in the CVM. So they declared that our judiciary was independent. And even then, there were so many scandals about harassment and assaults against the judiciary, including against the president of our Supreme Court, who's been very vocal about this. And we know that he has sent many reports to the European Commission on this matter. There's some areas in this report that show some, I would say, one-sidedness. Only one side of the coin is presented. For instance, we have a paragraph dedicated to the alleged lack of financial resources of the prosecutor's office, which are supposed to explain why they aren't leading efficient investigations, etc. But what's missing here is that this office is known for its unwise spending. And this year we had several scandals. One of them was the investment in extremely expensive, luxurious cars that one may use for holiday. Not sure how this enhances the investigative process. Also, millions were poured into the development of a police force associated with this prosecutor's office. This force doesn't really have a constitutional basis, so it's a bit a controversial issue. But in addition, this summer, it was with this police force that the prosecutor's office raided Bulgaria's presidency. And this is actually the main event that triggered the mass protests. And this hasn't even been mentioned in this report. And according to all leading constitutional experts in Bulgaria, I know this illustrates that the prosecutor's office disregards the important principle of immunity from which the presidency benefits, the Bulgarian presidency, but also a violation of the principle of separation of powers. A similar one-sidedness could be seen in the discussion on the Anti-Corruption Commission. The European Commission has shown a lot of sympathy to the fact that the Anti-Corruption Commission has the entire framework, but it hasn't achieved many results that we expected. Maybe that's because of lack of staffing. But my common sense dictates that a fish rots from the head down. And the previous head of this corruption last year, commission last year was forced to resign because of a corruption scandal he was involved in. And the current head is no other than the previous general prosecutor of Bulgaria, who was as controversial as the current one. And he was allegedly implicated into a series of scandals. And at least one of them is known to the European Commission because it's mentioned in the CVM report from 5 years ago. I think it's called Ianova Gate. But in this scandal, Prime Minister Borisov and General Prosecutor Tatarov instructed senior judges how to decide cases. And this scandal was never investigated objectively. In fact, there was no investigation into the facts. And the European Commission never insisted on a true investigation of this scandal. So it's just that this background leaves a very bitter feeling, and one may question if a person hasn't cleared his background is the right person to lead this institution. Now, last but not least, in order not to sound too negative, if there is a section I more or less agree with, this is the section on the media. I think this is the most objective section in this assessment. For the first time, I see the Commission overtly admitting that state money, including EU funds, may be used to finance pro-government media. And this is really troublesome. What is missing from the picture, actually the Commission says that some of these media are used to harass journalists, but these media are also used to harass civil society members, opponents of Mr. Borisov and his close circle, etc. And these media are also employed by the prosecutor's office for media trials. There are many instances where people have learned that they would be charged by the prosecutor's office from these media and not from the prosecutor's office. There are cases in which the prosecutor's office submits proof to these media before submitting the proof to the court. And I can elaborate some more if you wish, but there are even instances where the prosecutor's office overtly spreads false information. And this was even caught up by the European Parliament because they had some remarks in this regard. So overall, I think that the report is incomplete, and it is in the silence that we have most concerns.
Thank you so much, Ms. Vassileva. Ladies and gentlemen, the Q&A is open. Please send me your questions. But before addressing those questions to our panelists, we again would like to ask for your opinion in a next poll. And our question would be that, reflecting on the previous discussion, what do you think? Should EU institutions pursue a more confrontative or a more conciliatory strategy towards the EU's autocratizing member states? Again, you have 30 seconds to answer. Should EU institutions pursue a more confrontative strategy towards member states like Poland or Hungary, or a more dialogue-based, more conciliatory one? The time is over. Thank you very much.
Perhaps the question should have been not confrontational, but rather firm, but calm, rather than confrontational, which has a negative connotation. I'm just saying.
Thank you. That's partially true, but I think even the European Commission often refers that the institution would like to avoid a confrontational approach towards the member states. So I think, at least from their perspective, or choice of wording can be justified, but the results are again pretty straightforward. And if I remember well, the figure of 88% was the same also in case of the first question, but we have nothing to do with this fact. So 88% state that the European institution should follow a more confrontative approach. And I think it leads us to the questions that was asked by many of our attendees, whether it couldn't be justified to use a different approach in case of those member states where really a systemic undermining of rule of law or democratic standards can be observed. That's primarily a question to Mr. Herrmann, but I would like also to add further and a rather personal question to this one, that according to my opinion, it would be possible to establish the systemic deficiencies even under the current methodology. And I absolutely agree that the very same methodology should be applied to all of the member states. So I don't know whether it's really a methodological issue or simple a question that in case of some member states, and the problem is that these are the most problematic member states, the Commission simply didn't finish the homework which was started. And I think it's rather a question to all of the panelists. But first, Mr. Herrmann, over to you. You are muted, Mr. Herrmann.
Yes, thank you very much. So just to repeat, I mean, the tool that we have, that the Commission is presenting here is a preventive tool. It's not a reactive tool. We have reactive tools in the rule of law toolbox, and of course the preventive tool does not replace the reactive tools. I mean, just to recall that the German Council Presidency had a state of play on the situation in Poland and Hungary under Article 7 in the General Affairs Council in September. So this shows that there are different tools in the toolbox. Now, as regards the rule of law report, first of all, I'm very happy that you are discussing it, because it actually shows that the rule of law mechanism is going beyond the report itself. It's about creating dialogue and cooperation. And I think you are already part of this dialogue, of discussing it, of looking at, of course, from maybe from the perspective of your respective countries. And I hope that this will also happen in other European countries, and that altogether, over time, this will not be the last report, it's a yearly exercise, there will be a chance to create a European rule of law culture. And maybe this is something incremental, maybe that is a different approach, but that maybe that can also contribute from a completely new angle. And I think that it's important to give this approach a little bit of credit, a little bit of time. Now, one of the things we want to achieve again is to strengthen the interinstitutional cooperation. So we hope that we will see this rule of law dialogue taking place in the council that has taken place in the past, but that we can see that it has a new, that it will be based on the rule of law report, and that it will have an added value that 27 member states together are discussing a report. And if it works out, they would for the first time discuss the situation in specific countries. Of course, this is a voluntary exercise and this is a preventive exercise. And we stand ready to support this process. Thank you.
Thank you. Would anybody like to jump in? Professor Pech?
So to begin with, when it comes to dialogue, we have had an annual one in the Council since 2014. It has led nowhere. Second point, dialogue is the autocrat's best friend. That is the key lesson of all of my research since forever. So dialogue with autocrats is just going to lead to time being wasted while facts on the ground are being changed and then are made irreversible. Let me just give you an example. While we are dialoguing in Poland, they are appointing unlawfully plenty of what I call fake judges. Well, good luck, even if you end up with a court judgment finding that the appointment process was unlawful, to get rid of these fake judges. This is why time is of the essence when it comes to dealing with legal autocrats. They know the weaknesses of the EU's rule of law toolbox, and they're obviously going to use these weaknesses to actually change the facts on the ground. This is why to call for dialogue, I think, is actually just failing to learn from the mistakes of the past 10 years. You can only have a dialogue when you are engaged with good faith actors in a number of countries. I'm not going to name them again. There is no point dialoguing because you're just wasting time. This is not a dialogue you're having, but a monologue. Now, yes, in the long term, a dialogue is good to remedy just minor rule of law shortcomings. But here we're talking about essentially a deliberate blueprint to dismantle all checks and balances. We're not talking about minor, by mistake, rule of law shortcomings. We're talking here about the end of democracy as we know it. 10 years of dialogue with Hungary, well, what is the outcome? Hungary is no longer a democracy. Currently, on current track, Poland would not have an independent judicial branch by the end of this year. That's it. I mean, how much dialogue do you need? By the end of this year, there won't be a judicial branch properly in an EU member state. I'm afraid dialogue does not work when you're dealing with legal autocrats. And this is why I'm afraid the only institution left to save the day when it comes, for instance, to Polish judiciary is the Court of Justice. We're looking at the real prospect that the Court of Justice is going to do whatever it takes to save the day in Poland by concluding that essentially all Polish courts must now be quarantined because their independence has been structurally disabled. So my main point, I could go on, give you plenty of concrete examples. Dialogue does not work when you're dealing with bad faith actors engaged in rule of law backsliding. This is possibly one of the key lessons of 10 years of research on rule of law backsliding. Thank you.
Thank you, Professor Pech. Anybody else?
Yes, I would join Professor Pech in saying that time is always on the side of those who want to dismantle the rule of law. Irreversible, very severe harm can be done. So, for example, in some of my writings, I was proposing not only to adhere to the concept of systemic rule of law infringement procedures, which would see the systemic nature of dismantling constitutionalism, but also these procedures should be prompt, fast-tracked. These procedures should be prioritized, accelerated, and immediately interim measures should be imposed, preferably. This is a question whether these interim measures will be complied with and whether the ultimate decision in an infringement procedure will be complied with. but at least to give a chance to putting a stop to rule of law backsliding, a prompt response would be needed. I understand that dialogue is a European virtue, and I think all governments should be given sufficient time and place and space to present their positions. But when the argument is that this whole debate is blah, 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 then there is a point in time, I think, where we have to come up with dissuasive and persuasive sanctions or legal consequences attached to dismantling the very values that the European Union is based on. On the actual question, whether which was fortunately not addressed to me because I think this is a very tricky question, whether you can employ very different standards to democracies and those countries which are regarded by international organizations as something different than a fully established democracy. I don't have an answer. All I would give you is a warning. So what this exercise has shown us, that if it's a preventative tool and if the diagnosis of the Commission is that constitutional capture already happened in Hungary, and if it already happened, then we have to confess that the Commission did its homework. It had to scrutinize all member states. It did it, but this is not the tool that could prevent anything from Hungary because it already happened. And this is also the Commission's diagnosis. So it's not me saying that. What the lesson to be learned is that in such a scenario, you cannot balance these things, like saying that, well, there is a state institution that is entirely captured, but at least this is very well financed, right? Or you cannot say, yeah, these court proceedings are absolutely biased, but at least they are fast, right? So this would very much, or I would very much argue against coming up, for example, with indices or indicators, or just mixing these issues as if they were on the same level, and there was one on the plus side and one on the minus side. This is not how it works. So therefore, I very much appreciate this attempt on the side of the Commission to instead give a qualitative analysis instead of just attaching a number or an indicator to the member state in question.
Thank you, Professor Bárd. We have a question from Daniel Kellerman, and he asks that while the European Commission took the reports from lots of NGOs and watchdogs into account, why did it decided to leave the results of such really global research projects like the varieties of democracy, Freedom House, or the Bárd Justice Project, and their results on countries like Poland and Hungary out of consideration? And again, I also would like to add a further question from my side. Doesn't this preventive approach somehow also hamper the Commission's goal to facilitate a dialogue on the rule of law? Because I think to a proper interinstitutional dialogue, really a comprehensive overview would be required about the situation in the member states. And to be honest, concerning most countries, I think this comprehensive overview is indeed provided. So we have only a couple of cases, I think especially Hungary, where the time frame of the report is simply not covering the time frame of the autocratization process. And therefore, we have the impression whether in the case of Hungary, it really would be a preventive tool. Unfortunately, Hungary is the country where not a preventive tool would be required. But I fear that if this preventive approach is honest, it will somehow undermine the exchange with the Council, who doesn't necessarily need preventive information, for example, in the Article 7 procedure, and if the Council would like to use this report as a sort of source of information in the Article 7 procedure. Thank you very much.
Sorry. Is this a question to me now? Yeah. Oh, sorry. Okay. Sorry.
It's a question to you.
Yes. I mean, just to say on the aspect that you raised on the relevant stakeholder on the stakeholder consultation. So indeed, we have conducted a consultation that was the Commission has conducted a consultation that was public on its website, and where relevant stakeholders were invited to provide input. So this was actually an open process where stakeholders were not really excluded. But this being said, in the end, the Commission had to make a selection of the sources that it judged most relevant for this report. And of course, we are happy now to look at the discussion and then to draw the lessons for next year. But just to say that this was quite an open process actually, and also again as regards the input, where there's agreement, the input is being also made public on the Commission's website. So this is very transparent. And I was also happy to hear that when we speak about the different country chapters, you can see in the annexes actually which sources are being used, and also which organizations were met during the country visit. So it's quite you know, an open process. Now, speaking about the time aspect, I think it's important to underline that this report is to cover primarily important developments since the beginning of 2019. So of course, I mean, at some point we need to start, and this is a picture that covers these recent developments since the beginning of 2019. But again, that's inherent to a yearly exercise, and as you will have a picture in next year and the year after, then of course this may become something more than the picture itself. It becomes a kind of film that is tracing things. And of course, I understand that you're looking at certain things in the past, but maybe just to give it a chance to run its course. Thank you.
I mean, I take the point by Joachim that they have to start at some point, except that some processes are ongoing. So in the case of Hungary, it doesn't make sense not to pay attention to the EP resolution activating Article 7. I mean, if you look at the report on Poland, which does accurately refer to Article 7 information, then I don't quite understand why there is less focus on what the European Parliament's findings, ever since, in fact, I would go as far as the Tavares report of 2013. And looking beyond these countries, possibly something to do next year in the second edition, because yes, as Joachim said, this is obviously the first edition, so it was bound to suffer from some shortcomings. In fact, if you look at the evolution of the EU Justice Scoreboard, you can see how much it has improved after every annual edition. So there is hope that we're going to see similar improvements with this new rule of law cycle. However, I think what's missing is really, as you said, Daniel, we need to be given a clear indication of the country's rule of law achievements, or actually worst, if not achievements, actually shortcomings over a period of time. Otherwise, you don't really get the full picture. You read the transversal report, you simply don't see the destruction of the rule of law in Hungary since 2010. You just, the time frame is very important, and possibly, I don't see why the Commission wouldn't rely on the many rule of law indexes available. I'm thinking of the World Justice Project, for instance. Why can't we have some information at the start of the transversal report on the rankings of each EU member state when it comes to the rule of law? And then you can see if you take, because this, for instance, the World Justice Project does also give some very interesting information about the evolution of a country's adherence to the rule of law over time. I think if you miss this evolution over a long time frame, you're not going to be able to actually have any meaningful preventive effects. You're not going to see the systemic destruction of the rule of law if you just adopt a 12-month time frame. It's just impossible to see. In the case of Poland, you cannot understand the ongoing finalization of the destruction of judiciary if you don't start at the end of 2015. So I think, yes, the Commission had to start somewhere. But in the case of ongoing, especially Article 7 proceedings, it had to go back beyond 2019, I would think. Otherwise, as I said, you miss the wood for the trees. So possibly something to bear in mind next year. And possibly, in fact, you have given me a great idea, Joachim. What I'm going to do is possibly try to give the Commission the draft structure of his next rule of law transversal report for 2021. I think how could we improve the structure of the report, if you don't mind? And even if you mind, I'm going to publish it nonetheless as soon as I can find the time to do so. Thank you.
Thank you. We are slowly running out of time, but we had a very good question at the beginning, and that would be, and it's a question to you all, what would be your main recommendation and really constructive recommendation how the European Commission could improve its methodology in case of the forthcoming review cycles or future review cycles in the next years? I don't know who has already some very concrete and constructive recommendation. Who could start? Ms. Vassileva?
Oh, thank you very much. My recommendation is very concrete and it's based on the CVM and on this report. I'm under the impression that the European Commission very often takes words by governments at face value. I'm well aware that we have the principle of mutual trust, but when you're dealing with an autocrat or somebody who aspires to be an autocrat, their words should be verified. And I think this is clearly visible in this assessment on Bulgaria, that just part of the truth is there and the full picture just is missing. I think that we need more, maybe more serious talks with civil society members.
Thank you. Who continues?
My idea would be to actually explain what are the human rights, what's the impact on human rights, like on the rights of individuals in EU member states of each of those deficiencies of the rule of law. It would be beneficial to explain to wider public why this report is important, and also to explain better why this backsliding is actually negative for wider public. And I would suggest not to use euphemism that much. For instance, in the Polish report, we had a line on disciplinary proceedings against judges and a smear campaign against judges. And it was said that the debate in Poland is, just a second. Basically, it was said that the debate is very heightened by tensions, and I think it's just inaccurate, because you cannot say that this is a debate anymore when you have fake news, lies about judges published on the state broadcaster, and this is not a debate anymore. So I would just suggest that the Commission is avoiding such language in the future.
Professor Bárd, perhaps?
Yes. A straightforward recommendation would be to give a context, to contextualize the whole thing, to give it a framework, and just answering quickly one question by an excellent constitutional scholar from Humboldt University, Christian Boulanger. Yes, the Commission does go into the harassment of judges on page 4 of the Hungarian report, and it also gives references from international organizations doing this exercise of mapping what happens, but really extreme things happen, like disciplining judges for turning to the Court of Justice in form of a preliminary reference, and of course these heinous attacks dominated the debate. Yes, but coming back to my recommendations, I'm more concerned about the consequences. So I would, I do understand this very cautious approach by the Commission, not the harshest sanction at first, and promotion and prevention are more important than the response, which works very well vis-a-vis democratic states, but it should acknowledge that it doesn't work well vis-a-vis autocratic states. So I think the Commission should rethink the response prong and should stand behind all initiatives like the one by the Parliament or any other initiative really which gives a strong teeth to these exercises that are only, and I'm saying only in the quotation mark because it's important, but which are only doing the mapping. So I would give more emphasis for the response prong, and it doesn't have to be necessarily an Article 7 procedure, but also the Commission could directly, immediately, as of tomorrow, make a much better use of infringement procedures, for example. Thank you.
Thank you. Professor Pech.
So I agree with every single recommendation made by fellow panelists. I would say possibly just looking beyond this annual review cycle, let me just emphasize again what I think is the most crucial at this stage. The most crucial at this stage is containment. You don't contain the rule of law backsliding by producing reports. You contain rule of law backsliding through infringement actions. I'm a bit old-fashioned in this instance, but this is the only way of containing rule of law problems. Dialogue will not solve this problem. Reports might have a long-term positive impact. In the short term, what we need is a sense of urgency. Just to give you the example of Poland, regarding the muzzle law, I have never seen such a frontal attack on the most fundamental legal foundations of the EU legal order. We are now in October 2020. We have yet to see a reasoned opinion. By contrast, the Commission showed more urgency dealing with a bill not yet adopted in the UK, the UK withdrawal bill, 4 weeks, letter of formal notice. It took 4 months for the Commission to issue a letter of formal notice regarding the muzzle law. So when there is a will, there is a way, and the way forward is more infringement actions with interim measures. Thank you very much.
Thank you very much. And before wrapping up, we would like to conduct our final polling. And the last question is, what do you think, ladies and gentlemen, and especially after this discussion, what is the main reason of the EU's lack of impact on the democratic backsliding of EU member states? Again, you have 30 seconds. Is the main reason of the lack of impact the lack of appropriate legal tools? Or is the main reason of the lack of impact the lack of appropriate political will to act? Thank you very much. The time is over, but I see that you are still voting, but yes, the time is over yet. And the results are 82%, a bit surprising, but 82% of our attendees are stating that the main reason of the lack of impact aside of the European Commission and the European institution is the lack of political will to act. Thank you so much. We are over time, and therefore I would say a big thank you for all of our panelists for the food for thought they provided us today. Ladies and gentlemen, also many thanks for you being with us today. In 2 weeks, on October 14, we will revert our attention from the rule of law to the state of civil society in the region, and we'll discuss what strategies may have to build more sustainable civil society organizations in the shrinking spaces of the countries in Central Europe. Have a nice evening, see you next time, and goodbye.